as well as this that we're going to take you on. And also, we will be sharing details of today's webinar afterwards via email with other participants. So thank you, everyone, for being part of today. So again, welcome to today's webinar, Emerging Cyber Security Trends in the US, Addressing Risk is the New Black. And I'd very much like to welcome my co-host for today, and thankfully who has far more legal knowledge and expertise than myself. Otherwise, I'm not sure today's session would be as fulfilling. And that's Stephen W. Teppler, who is the Chief Cybersecurity Legal Officer at Mandlebaum Barrett. And not only that, is also the CREST America's outside general counsel. So welcome, Stephen, to today's webinar. Thank you so much for giving your time.
Andrew, thank you so much. And thanks, CREST, for inviting me to participate in this.
My absolute pleasure. No, so Stephen, I mean, you've been kind of dealing with stuff around cyber for quite some time, haven't you? I mean, in terms of a very impressive resume there in terms of you've spoken at RSA conference, obviously the massive cyber conference in the States over in San Francisco, kind of like certifications and stuff. I mean, just to get started, how did you kind of get involved in cyber and what sparked your interest?
It was many years ago, long ago and far away. We were involved in a litigation matter in which the issue of the validity of content that was submitted to the court came into question. And as a result, I wound up developing and getting 6 patents on trusted content verification, basically cryptographic processes for assigning time to digital information. I have a startup that's no longer in existence. Let's be nice about it. But this got me started. That's what happens when you're very, very early, when you're too early. But that's what got me started on the on both the electronic discovery and cybersecurity path, and that was back around 98, 99. So it's been a while.
Yes, gosh, certainly as someone who's been in what is now known as the tech game. I mean, when I started out, this industry didn't exist, and everyone was saying to me, "You want to build websites for a living?" And I was like, "Yeah, sure." Well, we had the last laugh, didn't we, Stephen? So here we are. But I certainly know as a previous business owner, it definitely has its challenges. So great to have you here, Stephen. Thank you so much again for your time, and thank you everyone for joining us today for today's member exclusive webinar. Just a few notes on the format before we get started. So Stephen is going to take us through a presentation with regards to today's subject matter, and we will walk you through that and as we go through. And Stephen, if you let me know when you want me to click that next slide, I will happily be doing so. And then after that, we will have a live Q&A session with Stephen, where you can ask any questions you want about not only just what's kind of in the presentation, but any thoughts and concerns you have about the new regulations that are coming into force. So if you drop those in the chat function, we will be monitoring that. We have a lovely project team behind the scenes there, keeping the cogs going, and they will make sure that we can field those. And then we'll have a nice Q&A session with Stephen, and then we'll close out the session and finish up for the day. Now, before we get started, a very, very important note, Stephen, we're about to have, which is this very important note that by no means does anything that we talk about today is offering any way legal advice in any respect, is it, Stephen? So
no, it's not.
So just if you do require legal advice, make sure that you consult an attorney or someone within your jurisdiction that can offer you the appropriate advice. But obviously today is about information and knowledge sharing and just making sure you are well aware of what's coming into force. Now, without further ado, I'm going to hand over to Stephen, who's going to take us through his presentation. So Stephen, over to yourself.
Thank you, Andrew. And you know, this is about as timely as can be. I've seen two events in the last couple of weeks. One of them yesterday, one of them an ongoing event that that directly implicates the presentation that we're making today. One of them is the Change Healthcare ransomware attack, in which a managed service provider of electronic records management, electronic prescribing, prescriptions, and claims management was attacked by ransomware, and wound up having paid, I think at the moment, $22 million it's reported in ransom to unlock its system, with questionable success from what I'm hearing. That's one thing. The second, which is even more appropriate, I think, for this presentation, is that there's an article that just came out this morning in law.com, which talks about how when there's a ransomware attack or a data breach, that the CISOs get thrown under the bus, right?
Yeah.
And it's to the audience here, to the people who are attending here, this is not news. The CISOs, the security people are always the pinatas in this problem, because they are considered to be the boys who cried wolf, right? And the sky is falling, the sky is falling. And between resources and not being able to convey properly to management, we have what's happened at Change and other companies. Then the FBI just issued its report, its 2023 report in the last few days, where the reported amount of ransomware attacks is approximately $12 billion in cost. There's been a 22% increase year to year over for cyber attacks. And there were 880,000, I believe it's 880,000 complaints filed with IC3 for, it's the FBI's online submission area for cybercrime. So we're not even there. I mean, there's an inflection point that we've reached, but the trajectory upwards is still happening.
Cool.
Go ahead, Andrew.
No, yeah, sure. I mean, I think I couldn't agree with you more, and it's certainly kind of an ongoing problem that we're very aware of, I think, on both sides of the Atlantic, but very much in respect to some of the things you just mentioned there today.
And now you have emerging threats. You have artificial intelligence or generative AI, which is it presents threats in a number of categories. One is for phishing and social engineering, obviously. The other is for code generation. And attack analysis and attack strategization. There's a whole new way of using generative AI or artificial intelligence, not only on the defensive side, but on the offensive side as well. So we can expect more problems to occur, especially with infrastructure as we move along. And the broad impact on businesses and the economy. When I was young, in college, I delivered pizza, right? Why am I talking about pizza in this session? Well, Anthony, who is the guy who owned this pizzeria, I would deliver pizza. And one day I was taking tax in law school, a tax course, and we were talking about tax evasion. And I said, Anthony, how do you figure out how much taxes to pay? And he said, the day that the IRS figures out how many pizzas I can make out of a 50-pound bag of high gluten flour, I'm out of this business. Which exposed the underground economy to me. All right. The new underground economy pales. It makes the old underground economy, smuggling, et cetera, pale in comparison. That's where we're facing today in terms of the cost to the economy and business and people.
Right. Next.
Let's go to the, yep.
Yeah.
So NIST has just come out with a brand new framework, much more human readable, but basically focusing on not only government agencies and contractors to government agencies, but the framework is now focusing on organizations, non-public organizations, to give them guidance on what you need to do to protect your, the availability, confidentiality, and integrity of information that you generate, whether you need to protect it under a NIST framework, under HIPAA, which is the, insurance-related healthcare information, or the General Data Protection Regulation out in the EEA, or PIPEDA in Canada. All of these regulations are being updated. California is now sharpened its focus of the consumer of the CCPA into now the California Consumer Privacy Rights Act, which is a CPRA, and California has just announced an increased scrutinization of organizations that violate that violate disclosure policies, opt-in, opt-out policies, and are considering punitive measures. In other words, high financial penalties, high monetary penalties and violators. Compliance requirements and organizational implications. If your organization is not required to comply directly with one of these standards or mapped to some security standard, your clients, your customers are going to be asking if you do, because they will have to be compliant. So this is the security supply chain. Everybody talks about software supply chain or what have you, but as we move along, the dependency for one entity to rely on another entity in order to business will implicate the having equivalent security policies and processes in place. Why don't we go to the next slide? And Andrew, you can cue me for when I spend too much time on this slide.
Not at all. It's all very interesting, but that's great.
So proposed bills, lots of proposed bills pending in various states. My state of Florida now has very close to being signed by the governor, Cybersecurity Incident Liability Bill, which purports to immunize private and public organizations from cybersecurity incident liability, provided, favorite word that you'll find in a statute, the condition is that you have to demonstrate substantial compliance with either HIPAA or NIST framework or an ISO standard. But this get out of jail free card means that you need to do the risk assessment, you need to have policies, you need to have people involved, you need to do everything that we as security professionals are requiring or proposing to our clients that we need. So this is instead of targeting specific threats or sectors, we're seeing this more globalization of security requirements that are being imposed on pretty much anybody or anyone who transacts business. In New York, the SHIELD Act in New York is especially important because any organization that holds New Yorkers' personal information, doesn't matter whether you're in Alaska or California or Alabama, if you hold any New Yorkers' information, you need to have, they call them guidances, but really what they're talking about are controls of administrative, technical, and physical controls to demonstrate reasonable security. And there have already been lots of organizations, including law firms, that have been fined by the state attorney general in New York for violating that. So there's state level initiatives. DFS Part 500 is pretty much similar for the banking and financial industry in New York. And so there's a whole plethora of cybersecurity laws that are percolating up. And I think this year, 2024, we'll see even more of them come to light.
And that's really interesting, that nuance there with New York and that sort of being so specific to a city, that no matter how you're showing data, the importance of that compliance piece. And I'm sure we'll have some questions on that when we get to the Q&A session. But
Florida's the same way. Florida doesn't even restrict it to Florida residents. So, jurisdictionally, it'll be questionable, but, does your organization want to be the poster child to see whether the law applies to you or not?
Yeah. And it reminds me a little bit of kind of like the situation we had here when obviously GDPR regulations were brought in, and, we couldn't have certain data passing through servers in other territories, and that, it's interesting to see how the conversation is moving along, and how the regulations are as well. And now we're on to the next slide, obviously, for growing corporate companies.
Senior level executives are starting to be targeted. And my comments earlier in the introduction about CISOs being the pinatas here are amplified because the CISOs are now being investigated criminally. The SolarWinds, I believe the SolarWinds CISO is being investigated criminally for the for the event, for the cybersecurity events, for the lack of taking appropriate care. And you can have a state attorney general come after you come after your organization if the incident that occurs is perceived to affect public safety, right? And what affects public safety? Infrastructure, large numbers of people, healthcare, you name it. You know, all the agencies with an F before them, the FDA, the FCC, the the Federal Food and Drug Administration, Federal Trade Commission, are all enhancing their focus to cybersecurity issues and looking at the executive, at the C-suite and executives to look for liability. This is illustrated by the new SEC cyber rules. Now, if you look at recent filings by publicly traded companies, you will now find some interesting disclosures that didn't happen before, because now the requirement is that if you have had an issue, you have to start describing what it was instead of your typical routine. You know, we operate in an area on the internet which is rife with problems, and so, you know, while we have reasonable security, but while no security is perfect, we can't be held to account for everything that might happen. Well, guess what? The SEC is going to look at your security infrastructure and see whether or not what you map to, whether or not you can demonstrate, just as in the New York Shield Act, whether or not you've had reasonable security based on the circumstances of your organization. And obviously, you know, a very small company has will have different circumstances and different needs and different requirements than a large company. But in the end, I don't see where a 5-person firm versus a 5,000-person firm will have any light between them in terms of needing to have multi-factor authentication and firewalls.
Hmm. Right.
Steps for conducting comprehensive risk assessments. First thing, ignorance is not an excuse. Ignorance is not a defense in law. It's not a defense in cybersecurity either. You can't assess a risk if you don't investigate whether you have a risk, right? And if you, you know, to this audience, that's clear. To the executive, to the executives or the C-level in an area, well, why should I worry about that? What's the likelihood of something going to happen? And you'll have that in an offhand conversation with someone, with a senior vice president or higher. And an offhanded comment of, well, you know, it could happen. That's not a risk assessment. The risk assessment is actually coming in and saying, okay, by the way, my position on this, my perspective is that pre-event, you always have an attorney come in during the risk assessment, because the attorney will be looking at each step and seeing what liability, what consequences can ensue from a problem that is either remediated, mitigated, or accepted, right? Or transferred, right? You can deal with risk in any number of ways. But the idea here is that keeping this under the umbrella of attorney-client privilege before an event occurs can shield a company and help them demonstrate that there has been reasonable efforts before an incident, even if an incident happens, that will make the consequences of an incident, you know, less severe, right? And so, you know, the technical part of compliance, you know, how are you going to configure your firewall, whether you're going to use, you know, this brand of equipment appliance or that brand of appliance is beyond scope for an attorney, but the capability that's offered by that is not. So if you choose a weaker appliance to do a very, very heavy duty job, that may have an implication in whether or not an attorney will say, well, you know, if you scrimp on this and you have a problem, somebody's going to claim, if you're sued or a regulator comes in, that you basically were negligent or
Mm.
you didn't meet a reasonable standard based on your circumstances for doing what you need to do. Incident response plans, policies and plans, disaster recovery, business continuity, backup, acceptable use, you name it. If you don't have your policies and plans in place prior, that's another way to invite scrutiny and liability from regulators or complaints.
Yeah, absolutely. Right, so that's the end of the presentation. So thank you for that. And I'm going to stop sharing my screen so we can have a chat and obviously also look at the questions that will be coming in. So Stephen, thank you so much first of all for taking us through that. I'm sure, as with so many of our people here, we found it incredibly interesting, incredibly useful. So just I mean, a question for me, if you ask, I mean, why is this happening? Obviously, is it a reaction to particular incidents that have been happening in terms of court cases and penalties, or do you just think that the way the industry is moving and companies and regulators are maturing, they're just getting wise to this a bit more, and they're just starting to pay a bit more attention, and that's why these kind of new measures and regulations are coming into force?
It took 40 years for seatbelts to be required in automobiles. And that was, that was before we had the advent of instant on information or instantly available information. And I think the rate with which we react to new incidents, to new circumstances has accelerated. So it really has been a slow march up to this point, but so much is happening and so much is being publicly disclosed about what's happening that this is a repetition and imprinting in people and saying, well, who hasn't gotten a breach notification letter, right? Who hasn't had to have a tax fraud based on an identity compromise take place? Who hasn't been able to get health care because they haven't been able to get to a practitioner who can provide the healthcare because they can't do it without access to diagnostic tools, which are in the cloud, which cloud provider is now, gone belly up.
Yeah.
So, it's hitting people in very, very, it's almost like whack-a-mole in reverse. They keep popping up. It's like a dam that has not just one structural defect, but a Swiss cheese number of defects. And, eventually the gestalt happens and you say, what's going on here? And that's what I think is happening. And I think it's finally, legislators are pretty non-tech savvy. Their children will be.
Yeah.
And maybe when their children become legislators, we'll know that. But that's also a problem that we're facing today in terms of, okay, this is important stuff, right?
Mm.
If your traffic lights don't work, people will die. If your hospitals can't provide healthcare, people will die. If you can disrupt air traffic, your economic losses will be significantly greater than you can even imagine.
Absolutely. No, definitely. I think we've, we were talking about this actually in a session we did the other day, and just in terms of, in the wrong hands, you could have bring down the whole, financial system. You don't be able to use even ATMs or anything like that. And as you're saying, kind of inviting all that kind of that chaos. So it's interesting to hear what you're saying. It sounds like to me that there's definitely been this maturing of understanding and that catch up, as you said, of people with what's actually happening and the implications. But I think what's most interesting, particularly with some of the stuff you said, was about the implications particularly for senior level colleagues and senior staff within organizations that as you said could be criminally investigated or,
Right.
or kind of face worse circumstances. I mean, that's obviously quite a daunting aspect for probably anyone listening today, or anyone kind of advancing in their career, thinking, obviously operating in the United States and how that will impact them.
And you don't want to be dragged in if you're on the operational side and you're in ops. You don't on security. You don't want to be dragged into a problem that you didn't create. And so, you know, you have this ever-present issue of not being listened to, either because of a translational issue or because of a financial, a resourcing issue. And, you know, what are we to do as security professionals to protect ourselves?
Yeah.
And that's, you know, that's a real concern. And that article that came out in ALM today in law.com really shows that it's, corporations exist for corporations' benefit, right? And, you know, somebody's going to, it's the old story of, what was it? National Treasure, I think, where, the Declaration of Independence had some secret message to get the Knights Templars
Yeah.
treasures, and at the very end, the person who actually who actually got to the treasure also stole or borrowed the Declaration of Independence, and the FBI agent who was sitting with him in front of Trinity Church in Manhattan after all was said and done said, "What do you want?" And the treasure seeker said, "I want not to go to jail." And the FBI agent just looked at him and said, "Somebody's got to go to jail." So somebody's going to be pushed under the bus. Somebody's going to be blamed for this. You know, it's a truth. And the idea is, how do you insulate or shield yourself from that as much as you can in doing it?
Yeah, and absolutely just having that robust plan in place. As we continue the conversation, just to encourage our participants today who are on the session, please do feel free to be submitting your questions for Stephen with regards to these new regulations that are coming through across the United States, and we'll be happy to answer them on that session. But it sounds like to me there's the main thing here is about some good auditing, going through your current processes, your current policies, your current structures. You know, do you have the right people and the right capacity to do it? Because one thing that working 20 years in the public sector here in the UK taught me was, these processes can get quite lengthy and time consuming and capacity consuming. Once they get going, lots of evidence required, a big audit trail. So obviously sounds like to me like going kind of really organizations taking the time to support that the process before any of that stuff happens, so they can respond to any requests for information. They can kind of deal with any kind of instance type stuff. But obviously, it sounds like to me it's just also protecting, their CISOs, their CTOs, their senior cyber colleagues, and making sure we've got not just their tech and cyber policies in place, but also their HR as well.
Exactly. And it's like what you brought to light is another issue, and that is a lot of companies are saying, well, we have cyber insurance, or we'll get cyber insurance, and that'll take care of everything.
Yeah.
Number one, it will not take care of your reputational damage when a state attorney starts investigating. It may not help you with certain types of fines that you'll get. It may or may not help you with class action litigation that might ensue for your organization. But cyber insurance is really interesting these days. It's evolved very, very quickly after being kind of a throwaway add-on for carriers, insurance carriers. In the old days, you just basically sign an application and that's it. But more recently, because of the onslaught of claims and the payouts have been incredibly high, insurance companies are now asking questions, and the questions are not aimed towards the executives, they're aimed toward the CISO. So I'll give you an example how this works. And I leave it to the attendees to think about how they would answer these questions. So the first question was, the first year made no mention of multi-factor authentication. In the questionnaire. And this questionnaires are attestations. The attestations are important. They're like swearing to something, so that if you lie or misrepresent, you can have your entire claim thrown out, or you can have the policy basically nullified. So first year, no questions on multi-factor authentication. No worries. The second year, you get asked whether or not you have multi-factor authentication deployed in the company.
Yeah.
Is the answer yes, or is the answer no? And I'm just a lawyer, so my first comment is it depends. So client, here's the hypothetical. Your client comes to you and says, well, we have some people using MFA and some people don't.
Yeah.
Okay. The question is, do you use, or do you deploy multi-factor authentication? What do you as a CISO respond?
Yeah.
Within your, it's a binary question.
Mm.
You answer yes, do you answer no? Who do you go to? You're the CISO. Who do you go to? Right? Do you go to your colleagues? Yeah, you go to your colleagues and they'll say, well, we don't know. And we've got some, but not all. And so you may go to your risk manager and they say, well, some, but not all. You go to the person, whoever it is. What should happen is that you should go to counsel. Why? Because if you misrepresent, you can be sued, not only not get insurance, but you can make a representation that you basically lied about. So for that question, whether you have multi-factor authentication, maybe you can get away with answering yes. Why? Because in contract law, especially with insurers, the contract is construed against the drafter of the contract. So that contract of insurance is what what the insurance carrier sends to you to sign. You have nothing to do generally with crafting it. So it doesn't say, it just says, do you have it? Oh yeah, we do.
Yeah.
The year after that, I saw the new version said, do you have MFA deployed through all users in your organization? Maybe now you don't have as much wiggle room as you did beforehand, right? But hey, you have to read these insurance policies carefully because they are chock full of legal language. And when it comes to a cyber insurance policy, you can be tripped up by any one of a number of things. Lloyd's, by the way, talking about cyber insurance policies, Merck had a major worldwide ransomware attack. The only reason they were able to recover at all, and they spent about $1.1 billion recovering, is that they had an offline copy of the domain controller in South Africa somewhere. And while everything else was poisoned, people in South Africa called up Merck's headquarters and say, well, we're ready to go back online. And they said, wait, don't, just hold on. So they were able to recover, but they sought insurance coverage. And a similar thing happened with Mandlebaum, the confection company in Chicago, both multi-billion-dollar companies. And the insurance companies said, well, this is what happened with Mandlebaum. Mandlebaum makes the claim 18,000 workstations and 9,000 servers taken offline. We're making an $800 million claim. The insurance company, Zurich Insurance comes back and says, no, we'll pay you 100 million. And Mandalay comes back and says, no, we want more. Zurich comes back and says, on second thought, we're going to reject your claim. Why? Because we have done our investigation. It looks like that ransomware attack came from North Korea. We're still at war with North Korea, so the war exclusion applies. We're not going to pay.
Yeah.
They've been involved in litigation. They settled eventually, but the litigation was 4 years in the making. Same thing happened with Merck. Merck got a rejection from its insurers. They won. They were able to prevail because the last appellate decision, which was not the final appellate decision, said, ransomware is not kinetic warfare. It's not bombs and bullets, right? Okay, fine. So rather than going up to the highest court in New Jersey, the insurance company settled because I think they didn't want a bad precedent of what the war exclusion is. So we still don't know whether or not, if a ransomware attack or denial of service or a breach comes from a country which we are not either harbors terrorists or quote unquote we're at war with. And why are we at war with North Korea? Because we only have there's been a pause. I forgot what they call it. It's not we've never signed a peace treaty with them. So there's technically, but anyway, so what happens is that you have to look at these insurance policies and say, what are we covering? What are we excluding? What are we excluding? And the phrases of these are really archaic. So it can be, you can have cover, an exclusion, an exception, and an exception to the exception, right? Is this something for the CISO to look at? No.
Yeah.
You need your counsel to look at and make sure that that you're covered.
Well, this is what I mean, exceptions upon exceptions upon exceptions, that's definitely not something that anyone beyond your legal counsel, and actually, someone who kind of deals more obviously on the marketing communication side, those words, those slight, even the slight phrasing can just mean so much from a marketing communication perspective, let alone legal implications where you might be fined. So we've had a question in from one of our attendees, Stephen. So on the cyber insurance topic, do you have a view on cyber risk quantification? We continue to see more and more on this area and with clients with different views. So what are your thoughts on that?
Risk quantification is necessary on the technical side. On the legal side, I teach cybersecurity law at a law school in Florida. And sometimes I make my students' eyes spin in opposite directions because they're learning things that they need to know before they even think about law. And you'll have your risk matrix, 1, 2, 3, 4, 5, low, somewhat, medium, pretty high, and then really high. So between 1 and 5 for a risk, where do you look at potential liability as arising as sufficient enough to pay attention?
Mm-hmm.
So the quantification might be for mitigating risk or for addressing risk. You might look at maybe 3, moderate, right?
Yeah.
Moderate risk.
Yeah.
But to me, even if it's like almost a moderate risk, what is the likelihood of something happening which will attract either a regulator or a class action type of data breach lawsuit? Yeah. And so, as a lawyer, it is, there's some legal doctrines which are, do you have a plaintiff who's a reasonably foreseeable plaintiff, a reasonably foreseeable victim of what can happen? Not only causation, something happens and then this is the cause of whatever, but is the organization or the person a natural target for that type of injury? And so that may not jive with your risk assessment. So if you have, if the your classic class action perspective is you can have a lot of little injuries which can be combined into one huge lawsuit.
Yeah.
And that's where you have to look at, high risk, low risk, high volume problems versus, high risk, low volume, which are always, concerns. And so it's, again, there needs to be a legal analysis as well as the actual quantification analysis.
Yeah, absolutely. And alignment piece, as you're saying, I mean, it's always, it kind of spoke to me in terms of what you were just saying then about the MFA question about insurance that you're saying prior. And I hope that answers your question, by the way. But, it's that kind of, there's that kind of almost objectivity versus subjectivity. What is bad? What is worse? What is good? And how do we quantify that in so many ways? So
the risk is before I forget, what you just brought up a great point. The test is not a subjective test. It's an objective test. It's what someone else in your position would reasonably do.
Yeah. Yeah.
And I apologize for interrupting.
So absolutely. So we're coming towards the end of the webinar. So if you've got any more burning questions that you would like Stephen, please submit them now before we finish. We'll give a bit more time to answer those. But one question that came, as you know, Stephen, CREST has kind of committees across the world, councils that we have, and we have our Americas Council, and our Americas chair, Tom Brennan, raised the question that you've been working with CREST members at the moment on some of their internationalizing some of their contracts. I wonder if you could tell us a bit more about the work you've been doing there, because I think the attendees will probably find that useful as well.
When it comes to contracting for CREST members, as a lawyer, we look to protect our clients. So while you want to provide the highest level of quality service to a client, you also don't want to leave your hindquarters hanging out of the window.
Yeah.
Right. And so, having a really robust, either an MSA or a statement of work that clearly outlines liability and indemnification and insurance issues is of utmost importance. Yeah. Because there's nothing more litigious than a client who doesn't think they've gotten what they've paid for. And the idea is you want to have the defensibility to say, no, we did. And perhaps you'd want to look at, instead of having a resort to a court, instead of if there's a dispute, maybe you want to include an arbitration clause. Yeah. So something is done in a more formally, but in a more favorable forum. Yeah. That doesn't necessarily have a jury of 8 people who may not know what the whole issues are, but they may not like you because they just may not like you. Yeah. Arbitrators are typically much more neutral when it comes to that. Yeah,
that's really great to hear. So before we finish the session, Stephen, final thoughts on the matter. So we have all these new regulations coming in, and a recap of that would be great, just in terms of as close of session.
Final thoughts are, everybody's under increasing scrutiny in our area in security. Make sure you document everything you do. Just document it. It's your best weapon, your best defense against anything that might happen. And if you see it, say it.
Yeah, and protect those CISOs and make sure they're being looked after as well.
Yeah. You know what? They're invaluable. Okay, and they need to be protected.
Well, and one thing I think that's always so important is that, as you said, although it's cyber as and of course I may be slightly biased here, people will probably think, but it's a shared vested interest in the business. Everyone has a stake in it. It's not just one person's responsibility. Right. Everyone needs to take responsibility for your cyber health and your cyber kind of stability. So I think within an organization, so
your health, period.
Yeah, and people understanding that, I think, is incredibly
more and more it's becoming better understood. The idea again is to look like the hero and not like the villain here.
I think that is a wonderful point to end on. So, Stephen, thank you so much again for your time today and meeting with us all. And it's been so useful to hear about everything that's coming to force and to hear all your thoughts on that. So thank you for me. Fantastic co-host as well. So thank you ever so much, and congratulations again on a fantastic webinar title. Kicking myself, I didn't come up with it myself. To all of our attendees, thank you so much for attending today. We hope you found today's session useful on these emerging regulations across the US, and a big thank you again to Mandlebaum Barrett and all the team behind the scenes who've been helping us put on today's member exclusive webinar. As I said, following today's session, we will be putting out an event detail page, which will have all the information from today, including a recording of mine and Stephen's conversation and his presentation, which will be sent out shortly. But again, a big thank you to you, Stephen, and everyone at Mandlebaum Barrett, and we wish you a good rest of your day.
Thank you.
Thank you so much. Thank you, everyone.